So discovery is something that is used frequently in family law matters, and you have both written discovery and oral discovery. Oral discovery is like depositions, okay? Most people have seen that on a show on TV. It's a little different than typically than what they show on TV, but that would be like me and my client if we were taking the deposition of her former spouse, okay? Or her current spouse in a divorce action. It's going to be him and his lawyer there. I'm going to have a court reporter. I'm going to have a videographer there. And I've pretty much got carte blanche to ask them what I want to do, as long as it is not just completely outlandish, okay? Written discovery, which is used far more than depositions. You try to avoid depositions if you can because of the cost associated with it. You've got prep time for the lawyer. You've got the lawyer time in there. You've got to prep the client, then you've got the videographer fees, and you've got the court reporter fees. So it gets expensive in a hurry. And if you have to take a bunch of them, it really gets expensive. Written discovery is less expensive, although it's also very time intensive. You have things that are called disclosures, okay? Disclosures are now required within 30 days of the filing of an answer. That's just been changed by the Texas Supreme Court. That's where you're going to have to list witnesses, both fact witnesses and expert witnesses, and you're going to have to do it quickly. You're also going to have to provide certain documentation much earlier than you typically would. So after disclosures, you've got interrogatories, okay, which are that's fancy legal terminology for just written questions. Depending on the level of the case, if you're a level 1, 2, or 3, is going to be determinative of how many interrogatories you can propound to the other side. You also have a request for production of documents, which is exactly what it sounds like. You're asking for documentation, common things. You want bank statements, you want credit card statements, you want the different things from financial institutions. If you have different corporations, you want the corporate documents, not just the formation documents, but the minutes of meetings and things like that have transpired over the years to understand what's really been going on. Not to mention you want all the internal financial documentation of those corporations. That's just kind of a starting point of where you would want to go. You also have admissions, which are statements that say, admit or deny that such and such. Those are used less often by some lawyers. I tend to use them pretty frequently. I think they're a great way to kind of box someone in on what their positions are. Another area that is incredibly common is the usage of subpoenas. So you might want to, in a child custody case, let's say there's an allegation that one party has mental health issues. You might want to subpoena the records from a psychiatrist or psychologist's office. Now, all of that stuff starts getting very sticky when you get into medical records, because then you're dealing with HIPAA laws. That's a whole nother conversation for another time. But those are the basic things that you're going to use in discovery.